again, people. Okay, so let's talk about this, the Kenosha kid, Kyle Rittenhouse trial. I'm going to go through it, all the witnesses, etc. It's going to be a week long, the trial, maybe 2 weeks, maybe 3 weeks. I think they picked 12 jurors and 8 alternates. When you have a case that has a lot of alternates, it's because they're either expecting to lose a couple for medical, they're expecting to lose a couple because of something that happens in a court and somebody gets caught doing something wrong. But to have 8 alternates for a few week trial, man, that seems kind of like a lot to me. I mean, 2 or 3 is normal. 8, I was kind of like, wow, that's a lot of alternates. Okay, so, and the way the alternates work is they get to hear everything. They're in trial every day. They're just like a jury, except they don't get to vote unless and until one of the original 12 has to leave for some reason. Then the person picked is up to speed. They've heard everything. The problem is when you're an alternate, you don't listen as well, and it's not really as important because you don't get to vote. If it was up to me, I would have the alternates vote, whether they were on the trial or not, just for the record, to see if you get a big consistency or inconsistency from the jury, to get some sort of statistics on, because they're not listening or paying attention, maybe that's why they're not, and maybe it's not good to have these alternates that just jump in like that. But anyway, I'm going to probably bump the speed up on this a little bit when it gets to where I can cover it and just hear the speeds and they're digging around, because it's faster, and my time is fast for the upload. If you don't like that I speed it up, you can simply go to the settings buttons on YouTube, you can hit playback, and then you can slow it down. So if I go up 125, you play it at 175, it'll be normal speed. All right? So hopefully that'll cut down some of the complaints. Why did you speed it up, Rick? I couldn't. All right, here we go.
Escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt.
Wow. He made that clear, which is good. You have to give. He's innocent until proven guilty. When in doubt, give the benefit to the defendant. It is up to the government to prove their case far and above, beyond a reasonable belief, and above a moral certainty.
We're going to hear the opening statements of the lawyers now. And we follow the procedure where the state speaks first. You know, sometimes you see these actress judges on TV, and they just destroy my enjoyment of the program when they tell the lawyers we're going to have the opening argument now. And I think, well, the only argument you're going to have is with me, because there's no such thing as an opening argument. It's opening statement. The argument is for the end, and that's when they're going to make their pleas to you to return verdicts in accordance with their beliefs. At this point, they're going to briefly acquaint you with what they think the evidence is going to show, give you an overview, alert you to the things they especially want you to watch for in the evidence, and they can be very useful to you for the...
Okay, opening statements sometimes they say can either win a case or lose a case. Some people say opening statements don't matter, closing statements are more important. Other people say, you know, witnesses are more important. So in a trial, you can pick and choose on what you want. Opening statements to me is a chance to influence the jury, to get them to believe you, to build credibility, and to make them think. For the prosecution is to make them think, I'm on your side, I'm the people, I'm the government, I'm representing you, the people, and therefore you should believe me and agree with me. That's what I think opening statements do, but whatever, here we go.
Those purposes, and they're brief. And then we can right into the evidence right after that. Mr. Binger, I think, is going to address you first on behalf of the state, and then Mr. Richards will have the opportunity to make an opening statement now, or if he prefers, he is entitled to reserve his opening statement to a later point in the trial. And
sometimes that's a good tactic, to not do your opening statement now, because the jurors have gotten so much through picking the jury. They're so over-inundated on bullshit that when you do the opening arguments, they're almost already tuned out a little bit. They just want to get to the witnesses. So sometimes it's better to hold your opening argument until maybe when the defense makes a really good case or a point, and then you say, I'd like to make my opening statement now, and then you get a chance to talk and readdress the jury. Plus, if you do it later, you can kind of incorporate things that already happened, and where you got good points or that you can make in your favor, and you can add that into your opening statement. So I think it's a good tactic to withhold on your opening statement till later on in trial, but whatever.
With that, again, no note, well, you haven't got the papers yet anyway, but no note taking now because this is a discussion by the lawyer. But please give them your attention. And with that, Mr. Finger, you may proceed.
The evidence in this case will show that on the night of August 25th, 2020, here in our community of Kenosha, the defendant Kyle Rittenhouse, who was 17 years old at the time, had armed himself with an AR-15 style semi-automatic rifle loaded with 30 rounds in the magazine.
Notice he said semi-automatic rifle. Automatic was clear and semi was low. This is lawyer tricks. He wants to win. This isn't about the truth.
With an AR-15 style semi-automatic rifle loaded with 30 rounds in the magazine. And using that rifle, he shot and killed Joseph Rosenbaum, an unarmed man.
An unarmed man who was chasing him, another guy in a mob who was throwing things at him, hit him in the head with a skateboard. Yeah, he's not going to say all that. He just shot an unarmed man. Okay, great. Yeah, we're going to start off with lies right from the jump street. This is why it's important not only for jurors, if you're ever a juror, to read through this shit. It's also important if you ever use force, you need to be aware on how the government will stop at no ends to get their win, not to get to the truth, if they were worried about justice and the truth, this trial would not be going on. This is a clear case of self-defense. This is a political trial against guns, and that's all it is.
The shot that killed Mr. Rosenbaum was a shot to the back. This occurred after the defendant chased down Mr. Rosenbaum and confronted him while wielding that AR-15. The evidence will show that the defendant fled the scene of the dead body of Joseph Rosenbaum without stopping to offer any aid whatsoever. And as he's running, word spreads from the crowd on the street that there is an active shooter running through the area. And the citizens there attempt to stop him. They approach the defendant. One person hits him in the back of the head. One person takes a swing at him with a skateboard. That individual is Anthony Huber.
So just listening to this argument, if you didn't see anything on TV and you didn't know what was going on, you would think Kyle got a gun, went out there, chased some dude down, shot him in the back, and then some helpful people in the crowd tried to stop him and make a citizen's arrest with a skateboard, and he shot them too. I mean, that's what I just heard this guy say, when if you've seen the video, it is absolutely the complete opposite of what happened. DAs, the government, will always lie and mislead people.
Eventually, the defendant loses his balance and falls to the ground. An individual who is the subject of count number...
He falls to the ground. He wasn't knocked to the ground because of being chased and hit. He fell to the ground. Okay.
Number 2, the unknown individual, runs in at that point and attempts to kick the defendant in the face while the defendant is on the ground. This unknown individual is unarmed. The defendant, in response, points his AR-15 directly at this individual as this individual is literally flying over his body and discharges that gun twice. Luckily, that individual was not hit. But clearly, if he had been hit, the wound would have been severe.
Okay, I want to point something out earlier because I was watching on Court TV a little bit earlier, and they're way ahead. I came up here. They've already seen a witness and everything, but I just wanted to do this from Yahoo so I could stop it. They're complaining, or the Court TV people, they're all supposedly lawyers, are saying that Kyle, this is Kyle, the 17-year-old good kid that exercised his Second Amendment right, that if he hadn't had a gun, they probably would have killed him, but you're not going to hear that. They are saying during his trial he yawns a lot, and he's acting like he doesn't care, and that turns off juries, and they're going to convict him because people are dead, and he's yawning. Take it. Look, people, that is so bullshit, and his lawyer better cover this to the jury somehow to sneak it in. And if it was up to me, I'd be asking a later witness, Have you noticed my client yawning during his trial? What's your, does that kind of affect your belief on a situation or something? He has to get out that yawning is a way to get oxygen into the system. People under stress will yawn. I've interviewed thousands of people and they yawn. Their heart rate is up. They are nervous. They're exerting a lot of energy. They may be getting an adrenaline jump because of their nervousness, and they can't undo all that, so they sit there. And because they're sitting there breathing, they're not getting enough oxygen. Their body is like, hey, I need more oxygen. My heart rate's up. Things are happening. You might be going in fight or flight. I need to get more oxygen in here. So it causes you to yawn. Believe me, Kyle is not yawning because he doesn't care. He's facing life in prison. His entire life. He's a 17, 18-year-old kid now. His whole life is about to be destroyed. And for these three so-called experts to say he's yawning because he doesn't care was just insulting to me. This kid is a nervous wreck, and he's yawning because his body is starving of oxygen because he's scared shitless. That's why he's yawning.
Perhaps even fatal. Immediately after that, Anthony Huber, who is holding a skateboard, comes in and reaches for the defendant's gun. He grabs hold of the gun and tries to pull it away from the defendant. The defendant is wearing his AR-15 strapped to his body. There is a nylon strap around his entire body, and the gun is slung from that, so it is essentially attached to him. Mr. Huber's efforts are unsuccessful because of that strap. And in that struggle, the gun winds up pointed directly at Mr. Huber's chest. The defendant pulls the trigger one time and discharges a round into Mr. Huber's chest, killing him instantly. A final individual by the name of Gage Grosskreutz has followed this chase on foot and has approached the defendant at this time. Mr. Grosskreutz is holding his cell phone that he'd been using to record the night's events for a live stream on Facebook in one hand, and a Glock semi-automatic pistol in the other hand. He runs up to the defendant. The defendant turns towards him with the AR-15. Mr. Grosskreutz raises his hand. The defendant then turns his rifle over, begins to examine it for a second. Mr. Grosskreutz takes this opportunity, and you will see in the photos and the videos, that he blades his body with his left hand, reaching towards the defendant. His right arm is pulled back. This is the one with the gun in his hand. And as he's reaching for the defendant turns the AR-15 and discharges the eighth and final round into Mr. Grosskreutz's right arm, the arm with the gun. Mr. Grosskreutz runs off, screaming for a medic. The defendant gets up and walks away. On that night, he killed 2 unarmed people.
Man, they are painting this kid as if he's just some crazy vigilante that went out there shooting up people. That is a damn shame. I hope the jury, when they see this video, remembers this and looks back and go, you're a freaking damn liar.
Shot at a third, at very close range, and wounded Mr. Grosskreutz in the arm, who was armed with a gun. It is the state's position that this evidence demonstrates the criminal charges against the defendant, his intentional homicide of Anthony Huber, and his reckless conduct towards the other defendants. Now, what I've just given you is the snapshot, but there's a wider context here. As we all discussed yesterday, this occurs during the context of the events following the shooting of Jacob Blake, which occurred on Sunday night, August 23rd, 2020. And we all know that within a short period of time after that, the community erupted in protests.
The community protests. I'm surprised he didn't say peaceful protests. They were burning up dumpsters. They were being freaking wild. This guy is such a freaking liar. I mean, how does a guy like this guy reminds me of Jeff Rising. How does a guy like this go home and look himself in the mirror and say, man, I did a good job today. I put some freaking kid who was about to lose his gun and get his ass beat by an angry mob of idiots. And he was out there painting graffiti up, putting out fires, and giving free medical aid to people that were hurt. And he got chased down and had to defend himself. And he shot people. And now me, I am a really cool dude. I'm going to try and take this guy's life away and put him in prison for life by telling lies and confusing the juror. How's that for America? You are a piece of shit, dude.
Looting, rioting, arson, and violence. Sunday night and Monday night were 2 of the roughest nights that our community has ever seen. We are well aware of the damage that the uptown area along 22nd Avenue suffered. The probation and parole office on 60th Street, the furniture business there. Car Source, one of their locations on Sheridan, and other properties around town that were damaged. Fortunately, in the entire sequence of events, this was all property damage. And one of the things we all agreed on yesterday is life is more important than property. up until Tuesday night, despite all the things that the community had experienced, no one had been killed.
Cops are killing people every day and nobody's been killed. I mean, this guy's going to sit up here with a straight face and say property is not as important as life. And we have cops killing people every day across this country, and nobody has died and nobody dies. And cops are killing them left and right. This kid's out here trying to help, getting chased and beat by an angry mob, hitting the head with a skateboard. He defends himself. And this piece of shit is up here lying to the jury, trying to take away his entire life. Dude, you are one sorry, pathetic piece of shit.
But what happened as the time went on was that the people of Kenosha, who felt a sense of outrage, began to protest. But like moths to a flame, tourists from outside of our community were drawn to the chaos here in Kenosha. People from outside of Kenosha came in and contributed to that chaos.
Yeah, so he's trying to say that Kyle came in from another place and contributed. Kyle came in to give medical aid and to help protect the community and stores. But he didn't make that clear. He must have just, Rick, he's a good guy. He just forgot that part. Okay.
And it caused many of our citizens to fear for their safety, fear for their homes and their families,
Much like Kyle, who had to defend himself.
fear for their businesses, and take steps to protect themselves, whether it is to arm themselves, board up their windows, move, or take time away from the community. All of those reactions were entirely understandable and reasonable. And no one here is going to tell you otherwise. As long as those are what you're left doing, there's no issue. But out of the hundreds of people that came to Kenosha during that week, the hundreds of people that were out on the streets that week, the evidence will show that the only person who killed anyone was the defendant, Kyle Rittenhouse. The evidence will show that hundreds of people were out on the street experiencing chaos and violence, and the only person who killed anyone was the defendant, Kyle Rittenhouse.
Thousands of cops out there shooting tear gas in cars, armed with weapons, bulletproof vests, lights, sirens, arresting people, all government backed to do whatever they wanted. Yet Kyle didn't have any of that. Kyle was a kid by himself being chased by a mob. Man, dude, you are so weak. I just can't wait to see what you say if your wife or daughter gets raped and a cop is standing there and he goes, you know what? Life is more important. I just couldn't, I didn't think I could pull him off and I couldn't shoot him. And you know what? Life is more important. See what you think about that, you pathetic. Ugh.
We will show you videos of some of the events that night, of police, tear gas, rubber bullets. And yet, the only person who killed anyone was the defendant.
Well, maybe if he had tear gas and rubber bullets, he wouldn't have killed somebody. Maybe if he had cars and radios and the police would have been doing his job protecting him, maybe he wouldn't have killed anybody. Maybe he wouldn't have to defend himself. Freaking government.
There are fireworks going off, which is a loud noise, sounds like gunfire. There are guns being discharged, the sound of gunfire throughout our community that night. Hundreds of people are there experiencing this, and yet the only one who kills anyone is the defendant. We will show you video of hostile confrontation between literally hundreds of people on one side of the issue and on the other side of the issue. People getting up in each other's faces. And yet the only person who killed anyone is the defendant.
He said that about 8 times now. Who thinks that's going to be a common theme?
Hundreds of people experienced those nights, experienced the night of August 25th, experienced that chaos. Hundreds of people. And yet the only one who killed anyone is the defendant, Kyle Rittenhouse.
That's a real big lawyer trick. Lawyers love to either get a photo or a drawing of them pointing at the defendant, and then they run around and brag later about how tough they are and how they got in the defendant's face and pointed at him and said, you're guilty and I'm going to send you. That's what you do to harden, usually DAs do that to harden criminals to try and get street cred on how tough they are. This little chicken wing punk ass is doing this to a 17-year-old kid that had to defend himself. Dude, you're weak.
Recently, I heard someone sort of tongue-in-cheek joke that jury services bringing in folks from our community and paying them $8 a day to help solve a murder. We're not asking you to solve a mystery in this case. In most homicide cases, the elements that I need to prove might be a little challenging, but here, there's no doubt, there will be no dispute in this record that the defendant had that gun that night, shot 8 bullets, 4 of them hit Joseph Rosenbaum, 2 of them at an unknown individual, 1 into Anthony Huber's chest, and 1 into Gage Grosskreuz's arm. That will not be in dispute. The central issue in this case is going to be self-defense. And the judge has given you an instruction which I want to highlight here, because there are some factors that I'd like you to keep in mind when you hear the evidence in this case.
Highlight means I'm going to try and undo that. If the judge read it to you non-bias, I want to undo that and make you biased to my side.
The defendant used deadly force. There is a privilege under our laws to use deadly force, but it's a very limited privilege.
Bless your government. Then it's very open and widely accepted.
That privilege, according to the law, indicates that the defendant can only use deadly force if he reasonably believed that the force was necessary to prevent imminent death or great bodily harm.
This is where the defense really has to point out that if this crowd, because they had guns, because they were shooting, because they were aggressive, because they had numbers, and they were actively chasing a guy with a gun, showing no fear that his client had a gun, and yet they were that ballsy that his client must have known that if they got that gun, they were going to kill him. And he better not lose that gun, and he better not let him get that gun. That's where I think needs to be a whole bunch of, focus.
To himself. In determining whether or not those beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the offense. The reason.
See, this says ordinary person standard for pesky citizens. For police, it's what another policeman with the same training and experience would have done. That's the big difference where people get confused, because when you ask other cops, they all go, oh yeah, he should have shot him, no problem. But when you ask other citizens who aren't trained, you're going to get 1,000 different answers.
Reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts, and not with the benefit of hindsight. You are, essentially, the people of ordinary intelligence and prudence who will apply that standard of reasonableness to the defendant's behavior and make a determination as to whether or not his use of deadly force was reasonable. Was it reasonable for the defendant to believe that the force was necessary to prevent imminent death or great bodily harm to himself? So, let's talk about the context of that evening. And I'm going to try and go in a little bit of chronological order to set things up for you so you understand the evidence that comes into this trial. The first witness you're going to hear from in this trial is a man by the name of Dominic Black. Dominic Black was, at the time of this incident, dating Mackenzie Rittenhouse, who is the defendant's sister. And through Mackenzie, Dominic Black got to know the defendant. And they spent a lot of time together in the months leading up to August 25th, 2020. In fact, on May 1st of 2020, Dominic Black bought the AR-15 for the defendant. That occurred up in Ladysmith, Wisconsin. Dominic Black used money that was given to him by the defendant to go to an Ace Hardware up in Ladysmith and buy the gun in Dominic Black's name. Now you might ask, why was it necessary for Dominic Black to do that? Why couldn't the defendant do that? Because the defendant was 17. And Dominic Black and the defendant knew that because the defendant is 17, he cannot purchase a gun. He cannot legally own a gun.
Okay, I didn't even know this was a straw purchase kind of issue here. You can't buy a gun from somewhere else. That guy, the first witness, has a trial coming up in January, but the prosecution is using him as a friendly witness. Now, they're going to say, oh, we just want the truth and we didn't promise you anything. But they know that if you cooperate and be a good witness for us, we won't come after you as hard. That's why this first witness is going to lose credibility right off the bat. He's hanging on charges from this same guy.
And so this was, in effect, a straw purchase on behalf of Dominic Black, on behalf of the defendant. After the gun is purchased in Ladysmith, Dominic Black and the defendant spent a little time up there at Dominic Black's family's hunting property. And
Now, the only way they knew that he went and bought this gun for him and gave him money is if they talked. Somebody talked. Nobody should know this. Had this guy that bought the gun from him, he wouldn't be facing charges right now because he didn't give me the money. I got my money. I bought it. I didn't like it, so I gave it to Kyle. Now we have no crime and no straw purchase. I think we have no crime. In Texas, you have no crime. You can give a gun as a gift like that, but I don't know about Wisconsin where this happened.
Fired both that AR-15 and one that Dominic Black already had. And the two of them are practicing using their AR-15s at a shooting range that they have on that property. And Mr. Black will tell you some more about that. Then they agreed that that gun would not go home with the defendant to his home in Antioch, Illinois. It would stay here in Kenosha at the residence of Dominic Black's stepfather in a locked gun case. And in fact, after the two of them returned from Ladysmith in early May of 2020, the gun stayed at that residence here in Kenosha until the day of August 25th.
Well, then I would argue that he didn't buy it for him. It was never in his possession except when they were together. Every time the Kenosha kid had that gun, he was with and in the company of the guy that bought it. and he left the gun in that state when he left, I would argue you may say he owned a gun and you may say the gun is his, but he never really took possession and had possession of the gun unless he was with the person that purchased it. So how can you say it's his gun when he can't even bring it back to the state he lives in?
2020. On the night leading up to August 25th, that Monday night, the defendant stayed over at Mr. Black's residence here in Kenosha. And the two of them decided on that next day, Tuesday, August 25th, that they would do something about what was going on in Kenosha. So at one point earlier in the day, they come down here. They work on cleaning up some graffiti on some buildings here downtown. Then they decide they want to come back later that night and protect a local business, a business called Car Source, which is located at 59th and Sheridan.
Wow, that sounds really nefarious. Those kids, they're cleaning up graffiti and they go help protect a business because a bunch of unruly assholes are burning down everything, and you're making all the assholes look like good guys, and you're making this guy look like a bad guy. Nice job, Poindexter.
Now, as I talked to you a little bit about yesterday, Car Source actually has 3 locations very close in this downtown area. One of them was on the east side of Sheridan Road, at 58th and Sheridan. And either on Sunday or Monday night, I think it was on Monday night, August 24th, that entire property was pretty much destroyed. There were multiple cars in the parking lot that were set fire and completely burned out. The building itself was damaged as well.
Oh, but all those protesters are good guys. They're not wrong. Kyle's wrong.
Right across the street from there is another Car Source location that also sold used cars. And some of those cars had been damaged on the night of Monday, August 24th. So on Tuesday, when the defendant and Mr. Black are out and about, they encounter one of the owners of Car Source. And they talk to him about protecting their 59th Street location that night. And there's some discussion about that. In the afternoon, Mr. Black and those guns around themselves when they come back to the downtown area that night. And eventually later that evening, they return. They meet up with some other folks that are interested in protecting Car Source. Originally, they start out at 63rd Street Car Source, which is the third and final Car Source location. But then they agree, we're going to go to the 59th Street, 59th and Sheridan location, and protect that location.
Okay, you were going to hear all this from the witnesses. I don't need to cover this. I'm going to bump forward here. Okay, so after he finishes, oh, you know what? We're at 30 minutes. I'm going to go ahead and I'll make this a part 2 for the defense opening statement.